There continues to be considerable debate surrounding the Constitutional Court's order to have anti-apartheid struggle veteran Chris Hani's assassin Janusz Walus released on parole. Walus was meant to be released on Thursday. However, after an attack at the correctional facility where he was being held, his release was further delayed. While some people believe that the rule of law should be followed, some argue that there are certain circumstances that need to be considered in cases such as this one. We take a look at how this case has been handled overall and whether or not the correct processes have been followed. University of Limpopo's Head of Criminology and Criminal Justice, Professor Jaco Barkhuizen, joins us now. Prof, thank you so much for your time and thank you for joining us on our program this morning. You know, the reaction to the court's decision to release Walus has been a deeply visceral one, but legal analysts, for better or for worse, believe that this particular issue is just, because the decision itself was sound in law. What do you make for that? I mean, is it still just when there's so much public pushback?
Okay, let's just break that down. It's this whole thing about the law is the law. But it isn't, it's more than that. Look, the apartheid was law. Was it just? No. The Nuremberg laws were laws. Were they just? No. So saying it's the law and it's just, it's two different things. Yes, it's the law, it's legal. Is it just? Does it speak to justice? Does it address the needs of society? Does it address the needs of the victims or the victim's family? That is what we actually should look at when we talk about parole, when we talk about bail. Just saying it's the law does not make it just. Remember, we're dealing with something called the criminal justice system. But some of the laws might not be just in terms of looking after those that were victimized.
Indeed. I mean, well, the benefit of parole is at the heart of this issue, as well as the debate around who is and who isn't deserving of parole. And I think for a lot of South Africans, having to confront whether or not a politically motivated assassin or killer in this instance should be considered for parole is deeply disconcerting for them. What do you make of that, this idea that South African society does not feel as though the debt has been paid in this instance?
Look, if you look at other countries, how they do parole and how South Africa does parole, there is a disconnect. You have sentencing options where you have life imprisonment with the possibility of parole, and then you have life imprisonment without the possibility of parole. And what dictates these two different sentencing is the effect the offender or the offense has on the victims and on society. When we have to give someone parole, we should look at if we release this person. Is there true remorse? Is there contrition? Releasing this person on parole, what is the threat this person still poses to victims and society at large? Is this person rehabilitated? Now, the problem with that question, is the person rehabilitated? Some offenders have a low propensity of being rehabilitated. Here I refer to you to serial killers, serial rapists, pedophiles, and people with such ingrained extremist views that no amount of rehabilitation programs or psychological intervention change the views they have about society and the people in society. And another problem with rehabilitation in South Africa is, as we know, the recidivism rate is in the high 80s, which means for every 10 offenders released, 8 will reoffend and go back to prison. And we have to relook how we do parole in South Africa. We have to take into consideration what society feels is just. Is it just? Just because it's legal does not mean it is just or it deserves justice.
This issue of, rehabilitation and remorse and contrition being a requirement, at least, when considering parole, I find very interesting, Prof, because as we know, Janusz Walus was essentially a hired gun. His role was a very mechanical, a very technical one in this instance. It was to take out a very prominent political figure who was charismatic and had the ability to really influence the South African people at the time. So a very critical move in removing him from the political space at the time. Does someone who's a hired gun have the propensity to feel remorse in a situation like that, given the fact that at the end of the day, it was an assignment? He had no relations or any sort of political allegiance to any political organization within South Africa that could have created or fostered some sort of understanding of the context at the time. He was, as I mentioned, essentially a hired gun. Can someone in that position later on show remorse? Can they have capacity for contrition?
Well, everyone except true psychopaths have the propensity to eventually feel remorse or show contrition. But here's the thing. We need to, especially, I know the Department of Correctional Services does this victim-offender dialogue, and it places the burden on the victim. First, you will have to have psychologists look at, is this true remorse or contrition, or is this just an offender playing the system to get parole? But someone that's a hired gun, remember, you're still human. Eventually, if you're not a psychopath, you will hopefully feel remorse for your acts and feel remorse for the damage you have done. This is why restorative justice processes in parole is so important. But we should not rush these systems, and we should always have the victims' voices as the central theme when it comes to looking at remorse, looking at contrition, looking at whether parole should be granted.
I mean, talking about the victim-offender dialogues that you mentioned, Professor, the South African government is of the view that it enjoys high rates of satisfaction when it comes to those dialogues. What can you tell us about the inner workings of that environment? We're obviously hearing government side in this instance, but, when you watch Chris Hani's widow, Medimpo Hani, being so upset at the court's decision, one has to wonder how these dialogues work, and if, indeed they fairly and justly so take into consideration the effects that the crime has had on the victim.
Yeah, look, in theory, a victim-offender dialogue is a brilliant piece of restorative justice practice. How it's done in South Africa, it's when the person is up for parole 6 months before that, then let's rush the system, let's get the victim and offender together. And it's usually from the offender side, they know if they do a VOD, it looks good when they go in front of the parole. A true victim-offender dialogue starts years before. And the victim is at the center of a true victim-offender dialogue. If a victim does not want to be part of a VOD, that's the victim's choice. That's their right. Under the South African Victim Rights Charter, you as a victim have the right to express your feelings. And then when we talk about the parole board in itself, if you do not have money, or the Department of Correctional Services don't know where your address is, the chances of you as a victim giving your voice, your opinion to the parole board, whether the victimizer should be released, is extremely rare. It's low. Only if you have money and you follow the case and you know when parole is up for the victimizer, do you have can you then be part of that? Whether the parole board then takes into consideration the feelings of the victims, as we see now with the Hani family, it is up for debate. And this is the problem with our current justice system, where the rights of the state and the offender is placed higher than the rights of the victim. And until we address this imbalance, stuff like this will keep on happening. We will keep on releasing people on parole that might not really should get parole, or we will give people bail that's out already on bail for similar offenses.
I mean, Prof, with regards to this specific case, that the Con Court made the decision. It's the highest court in the land. And so we've been seeing all these demonstrations and protests against that order. Are those efforts futile, given the fact that there really isn't much room to maneuver at this point? It's pretty final, the decision that's been made. Or is there hope in the sense that we can push for reform when it comes to some of the laws that you mentioned that currently have these fault lines when it comes to dealing with parole in South Africa?
Look, for this case, it's a done deal. It's done through the Constitutional Court. There should be reform now. Our legislators, our government and members of parliament, and the lawmakers should now realize that parole is a very contentious issue, that sentencing is a very contentious issue, that as soon as possible we should re-legislate what parole means, what life imprisonment means. Like I said, we would have to have two systems. Life imprisonment without the possibility of parole, based on the heinousness of the crime, based on the idea of, is it possible for this person to be rehabilitated? Is there, what threat does this person have for future victims, for the current victims, and for society at large? And the problem with the current legislation says that whatever a sentencing judge says should not be considered when looking at parole, which I find a huge logical disconnect. The sentencing judge has gone through all this facts and evidence. So if a sentencing judge says this person is such a danger to society or to the normal functioning of society or the victims that they should not be released because the propensity of violence or the propensity not to rehabilitate is so high that this person is a danger for everyone. Just to have that overruled by the parole board it flies in the face of logic.
Indeed. Well, Professor, thank you so much for your time and thank you for joining us on our program this morning. That is the University of Limpopo's Head of Criminology and Criminal Justice, Professor Jaco Barkhuizen.